if you're taking 1,000 feet or a small retail space, but that is your livelihood, it's critical. You have to get that right.
That's right. That's right. And that's a good point, because some of our clients, the smaller business folks, they don't have that leverage, right? And so that's a serious point they lack. Some of the provisions that we see, it might boggle your mind to think that rent would be a provision that would go overlooked, right? That's the one we're looking at first.
Absolutely.
But when that rent increases is something that doesn't get thought about clearly. Like how am I going to grow in a period of 2 or 3 years that will allow me to pay this increased rent?
Yes.
Obligations for improvement. Sometimes that's not looked at very carefully. There are a number of provisions within the leases for small businesses that oftentimes get overlooked, and those are two of them.
That's a great point.
Yeah, it is.
Because there are management fees, there's fees when you make alterations, there's interest on late payments. There's a number of terms that you might not negotiate in a letter of intent, but that are still negotiable within the document. So you made a great point, as usual. But that's in addition, we always want to make sure the lease matches what was agreed to, and we find those areas that are of greatest exposure or where there's a financial implication that you may not be aware of on the face.
I'll give you one key example when you talk about implications that I've seen a lot, and this is on the small business side, but it's personal guarantees. And typically you'll have and I got to think about a retail person comes to mind, that maybe a Smoothie King operator, first shop, they're trying to get their heart and soul into this business. They see a personal guarantee there, and they're told by the landlord, hey, this is what you do. What they're not told is there could be a burn-off period, that in and of itself is negotiable. They're not told what other people are doing that are larger, that have several stores, that just won't refuse to even touch that. And so the landlord has all this leverage. They see where their assets are. They have a personal guarantee if something goes wrong, and that person is just in a really bad position. Now there's all this extra stress.
Right.
So that's one provision that I personally see. And I want to know, is there anything else in the rent category or personal guarantee that you guys see that may also be that huge?
Well, guarantee. I'll take this one. Guarantee. You mentioned the things that they're not told, the small business owner is not told. Are they told what a guarantee is?
Yeah.
Now, it's incumbent upon them to figure that out, to go and ask, to seek advice, to ask what a guarantee is. But I think and the terms that are in these guarantees, like unconditional, what does that mean?
Yeah.
Right? What does it mean about when you can pursue me versus when you can't pursue me? So we see a number of provisions that get overlooked because the jigsaw puzzle is just so long. It's so big. And although I might have been excited about it, after 5 pages, I'm worn out.
I'm working with a very smart lawyer right now, and we got his lease, and he looked at me and said, this is a bear. And this is a incredibly sophisticated, very smart lawyer. He just said, this is heavy. There's a lot here. Yeah. And that's my job, is to help him identify, where in these provisions do we need to focus, and try and be strategic about which ones we touch and which ones we can live with. But
makes sense.
I helped a client reduce a guarantee on a 4-year lease from 4 years to, if we didn't default in the payment of rent for 12 months, the guarantee goes away.
Nice.
So you may need to get a guarantee or some limited guarantee, but you can burn it off. You can minimize the exposure over time, and that's a helpful relief.
That's a value add.
Another term that I've seen come into play a lot are what are called relocation clauses. And for smaller tenants, a landlord is going to want the ability to move a smaller tenant if he can make a bigger deal.
Oh, yeah.
And sometimes how that lease will come to you is a relocation where the landlord has a right to relocate you, and you know that up front. But what they should do is relocate you to substantially similar space with very similar finishes and layout. You should have a notice time. They should pay all the costs of doing so. Well, I've seen relocation clauses come where the landlord isn't obligating themselves to pay some or all of those costs. And so if you just say, hey, I agreed to relocation provision, so this is fine, well, maybe you get relocated and you don't get the same type of space, or the space is bigger than you need, and you're asked to pay the increased rent because the square footage is larger. So we'll try and limit those to make sure the space is comparably sized, or if it's bigger, you don't pay more rent than you already were on the hook for. So the landlord can't escalate your rent by moving you from 1,500 feet to 2,300 feet.
Yeah,
just
smart.
Getting some of those costs covered, making sure you have notice. So that's another provision, because often you'll take a space, and whether it's retail or office, and you'll design it the way you want.
Yeah.
And then if you're asked to move 6 months later, and you're starting with something that looks different than what you had bargained for, that's going to be an issue.
That's right. Never mind that.